Former acting High Court judge and law professor says it's unclear what impacts the latest decision by the Constitutional Court will have on the final outcome of the rescission application of the former President Jacob Zuma. The country's High Court today asked the legal teams of the former president, the State Capture Commission and other interested parties to make submissions by August the 18th on whether its decision to hold Zuma in contempt of court and imprison him should be considered in terms of the UN International Covenant on Civil and Political Rights, a treaty to which South Africa is party to. Sherwin Bryce-Pease spoke with Professor Penelope Andrews of New York Law School, and here's that excerpt of that discussion.
Professor Penelope Andrews, as always, thank you for your time and thank you for speaking with us.
Always nice to talk to you, Sherwin.
So the Constitutional Court has asked the legal teams of former President Jacob Zuma and other parties to submit documents addressing the international, legal and constitutional implications of his detention and how specifically the UN's International Covenant on Civil and Political Rights, to which South Africa is a party to, could be brought to bear on the rescission application before it. What do you make of this development, Professor?
You know, I make two things of this development, both political and legal. Let me just quickly say the political part. This reminds me a little bit about former President Trump, who has been trying his utmost to delay court proceedings in which he has to answer specific questions. So to some extent, I see this as another delaying tactic on the part of the Zuma team. Legally, of course, the international covenant and international law generally applies in the South African context, and the Constitution states that in considering their decisions that the courts apply international law. So to some extent, of course, the pleadings, I have not seen the pleadings, but I imagine that they will raise these questions. Whether it changes the ultimate decision is a different question. But, you know, legally, this is what the Zuma team is entitled to.
So the covenant commits its parties to respect the civil and political rights of individuals, including the right to life, among others, and rights to due process and a fair trial, right? That appears to be the crux of this latest legal exploration by the court, the notion or the rights that surround the due process and fair trial arguments. What do you make of that specifically?
The way I see it is that the Zondo Commission, which is an administrative tribunal appointed by the president, certainly has legal powers. It has the power to subpoena, but it does not have the power to imprison people. So this was an appeal from an administrative tribunal to the Constitutional Court. And of course, the Constitution allows the Constitutional Court to sit as the court of first instance in these kinds of matters. So very generally, due process has been satisfied just if one looks at the provisions and the actions itself. As an aside, I'm not sure strategically that the Constitutional Court taking the case as the court of first instance might have been the best decision. I think if this had been sent down to the High Court first, in which the High Court could have gathered evidence and particularly witness statements and so on, and then the Constitutional Court sits as the court of last resort, it may have satisfied these due process requirements. But I am not suggesting that due process was not satisfied. It was. But I think strategically, if this case had made its way up through the High Court, the Supreme Court of Appeal, and then onto the Constitutional Court, this area of law could have actually been developed by the court, because it gives the opportunity to develop the law as it sits as an appeal court.
Yeah, I mean, you're specifically now referring to Section 167 of the South African Constitution, which says it's clear that when it is in the interest of justice and with leave of the Constitutional Court, that a person may bring a matter directly to the Constitutional Court. So does that not then render the whole due process argument moot? Because this was a constitutional process. The Constitutional Court can sit as the first.
I think it does render the argument moot. And as I was absolutely. Absolutely, it can. And I am not suggesting that the court was wrong. I think that the constitutional requirements have been adequately met, as you just read out, Section 167. What I'm suggesting is strategically, as a legal strategy, that it might have been better. So I am not saying that the Constitutional Court was not within its right. I agree with the judgment, and I think that due process was satisfied. But just as a strategic matter.
Okay, so let's look at what the latest order of the court is. The court says that in light of Section 39.1, and allow me to get a little bit in the weeds here, Professor, yes. Section 39.1 of the SA Constitution, which says that when interpreting the Bill of Rights, a court must promote values of dignity, equality, and freedom, and must consider international law and may consider foreign law. Very interesting. Additionally, whether this court is obliged to consider the UN Convention when construing sections 12.1b of the South African Constitution, which says a person has the right to not be detained without trial. And then again, Section 35.3, which details the specific individual's rights to a fair trial, including a public trial before an ordinary court, to be present when being tried, to remain silent and not to testify during the proceedings, and not to be compelled to give self-incriminating evidence. That's just sort of a summary of what the court is asking for, interventions from the various legal parties here. That really is what the court is asking for representations. What do you make on that scenario?
Well, I would imagine if you read the judgment, the court obviously considered a range of questions, and you're quite correct. The Constitution does mandate the court to consider international law and the various processes. The court has done that. The court is familiar with the use of international law. In the Azapo decision, for example, and other decisions, the court has been very comfortable in balancing international law, South African constitutional law, the values of the Constitution, et cetera, et cetera. So I am the appellant can make all kinds of claims, and these claims are justifiable. But this is not to suggest that the court has not considered it or that the court has not been comfortable with balancing international law, the application of international law in the South African Constitution and constitutional law. As I said, it has done it before. But the second question is really, when one looks at the International Covenant on Civil and Political Rights, with respect to this question, I am not persuaded, looking at it, that it will change anything, it will change the outcome, because in fact, if one goes back to the due process question again, ex-President Jacob Zuma has had ample opportunity to have his, to respond to the subpoena, to have access to the courts. He's used the court system in various ways not to answer specific questions that he's required to answer by the Zondo Commission. That's the core of the question here. And of course, the due process issues he can. The international law is very much part of the constitutional framework. I'm not sure if it changes anything. Yeah, because it's a due process argument, but is it a persuasive argument?
Section 35.3 of the Constitution, not to be compelled to give self-incriminating evidence. Is that an argument his team could use here?
Well, self-incriminating evidence is, the idea is that you will disclose something that will be to your detriment. But when you think about the Zondo Commission and the evidence that has been gathered by the Zondo Commission, in fact, you would say that the commission was requiring the ex-president to explain, in fact, to exonerate himself. He could have provided information, not to incriminate himself, but actually to explain the various activities and so on. So I think that, that argument, one has to look at the context and the facts. And the facts just don't coincide with the arguments that he's making.
Couple more quick questions for you, Professor. You've talked about the political and legal implications of all of this. What do you mean?
Well, the political and legal implications, I think that the court deciding immediately after its decision to reconsider its decision is both a legal question and a political question. Because the political question is the authority of the court. It is almost unheard of for a court of last resort to immediately revisit a decision it's made. So, for example, in the United States, Roe v. Wade has been argued, the abortion case has been argued up and down the federal courts to the Supreme Court since the 70s. And an issue can be litigated continuously. But an issue cannot be litigated when the defendant who loses says, I am not happy. I want you to revisit your decision. And this is essentially what Jacob Zuma is asking the court. And from my perspective, I don't believe that it serves the court's authority and credibility to have decided to hear the case.
So it hurts the court's integrity. It doesn't bolster its integrity, this latest development. Is that what you're saying?
It could. I'm not saying with absolute certainty that it will either way, but it could, because the court has spoken. And the court, obviously, the judgment of Justice Kampepe sets out a well-reasoned argument. Whether you agree with their decision or not is a different question. But the court has deliberated on the issue, and I fear that its credibility and authority may be questioned by its revisiting this question immediately, because the ex-president is unhappy with the decision.
Penelope Andrews, Professor of Law at New York Law School, convener of the South African Reading Group at New York Law School, and a former acting judge of the North Gauteng High Court, as always. Thank you very much indeed.
Thank you, Sherwin.